Hello everyone, very warm welcome once again to your favorite channel, that is StudyIQ IAS English. I'm your educator Praveen Mishra, going to discuss another burning topic of the day. Right, as you can see on your screens, it's the former Chief Justice of India, Mr. Chandrachud. The question here is the authority or the power of judiciary, specifically the highest body in the judiciary, that is Chief Justice of India, is undermining or kind of dominating the power of Indian Parliament? Is it true that judiciary is right now focusing or having extra amount of power as compared to the Indian Parliament? So, to begin with the whole topic, before beginning the whole topic, just let's discuss one very important aspect. What is this aspect all about? Here is the question that we need to answer. Is Indian Parliament supreme? Can we call is Indian Parliament supreme, or not even the word supreme, there is another word that is sovereign. What does this word sovereign means? Obviously we know it very well. When I do not have any godfather standing above my head, right, not giving me any sort of instruction to do this and to do that, when I'm free to take up my own decisions, act in a way I want, that is absolutely having the liberty, then I consider myself as sovereign. India as a country is absolutely a sovereign state. But now here, the question is the Parliament of India supreme or sovereign as well? Let's discuss the parameters first of all. According to the theory of rule of law, propounded by one of the very famous political scientist, A.V. Dicey, what he has stated, that is also mentioned in our Article 14 of the Indian Constitution, that states equality before law. Right? What is Dicey's rule of law, or the simple aspect of the word rule of law? Okay. As in, law is supreme and law is absolutely non-biased. Now, who will check that whether law is biased or not? Who will be having this authority to check whether the law is biased or not? So, from the perspective of India, it is, yes, the Supreme Court. And make one thing clear, even high courts, they do have the power to check the validity of the law passed by the state legislatures as well as the Union Parliament. Okay, so just here considering Supreme Court. Supreme Court, it is what? The custodian, right? Or the guardian as well. Custodian or the guardian of the Constitution, right? How come that possible? So, it is possible through another theory that we have learned from the French political philosopher. His name was Montesquieu. He gave the theory that is known as theory of separation of powers. We have also called it the theory of checks and balance. It was around 17th century when Montesquieu, who was a French political philosopher, obviously political, he wrote a book. The name of the book was The Spirit of Laws, in which he propounded this theory, that is theory of checks and balances or the theory of separation of powers. According to the theory, the democracy has got three organs. Okay, the democracy has got three organs. The first one being the legislature, second one being the executive, and the third one, that is the judiciary. So according to the theory, all the three wings works independent of each other and do not interfere in the matters of each other. So what is the role of the legislature? To make laws. What is the role of executive? To implement the laws. And what is the role of judiciary? To defend the law as well as define the law. And because of this particular task given to judiciary, judiciary becomes the custodian of the constitution, or you can say simply the guardian of the constitution, right? And now, talking about this particular question, is Indian Parliament supreme or sovereign? So let's discuss one more parameter. What is this? Judicial review. Any law, judiciary, Supreme Court being the custodian or the guardian of the constitution, any law which is passed by parliament, any law which is passed by parliament will be checked by the judiciary, specifically by the Supreme Court, that whether the law respects, follows, and in contrast or actually in the same lines as of the provisions or the protocols of the constitution. In case the law violates any part, any provision, any single line even of the constitution, then the judiciary possess the authority to immediately, I'll repeat again, okay, immediately without any discussion and delegation, to declare that law invalid, that is unconstitutional, and eliminate that law totally, right? So because of this, we have got the question here, that is the Indian Parliament supreme? No, Indian Parliament is not supreme, it is not sovereign. Why? Because the Parliament of India cannot take any law, cannot implement any law, right? Cannot make any law which is inconsistent or having opposite provisions with regard to the constitution. Hence, as a result, Indian Parliament is not considered. Guys, please make your notes very carefully if you are making, right? Indian Parliament is not considered sovereign, right? As because judiciary is there to check parliament. And so is judiciary. It is also not absolutely a sovereign body, though independent, but obviously parliament is there because we have got the theory of checks and balances active totally in the Indian subcontinent, in the Indian polity, right? So now, talking here about the news. What is the news first of all? So here is the news. Law Ministry forwards complaint against former CJI Chandrachud to DOPT, that is Department of Personnel and Training, for action. And what is the whole news? Here is the whole news. The Department of Justice at the Ministry of Law and Justice has forwarded a complaint filed by former Patna High Court Judge Justice Rakesh Kumar against former Chief Justice of India D.Y. Chandrachud, okay, to the Department of Personnel and Training for further action. In case further, Justice Kumar had filed a complaint before the President Draupadi Murmu on November 8, 2024, seeking a probe against former CJI over allegations of improper conduct and potential abuse of power. So far, this is not yet justified, okay, that whether the Chief Justice of India has, abused his power or has taken any sort of, unethical advantage of his position, right? So the allegations is improper misconduct or improper conduct as well as abuse of office. But here is the fact. Justice Chandrachud, who has been into the limelights, into the news headlines every now and then because of his fierce and harsh judgments. Those judgments which have, underlined many of the times the authority of the government. But on the contrary, on the very opposite side, there have been instances even where Justice Chandrachud has given judgments or statements in favor of the government when the speculations or anticipations of the people were that no, this will be the judgment which will be opposite, on the opposite lines of the government's argument. So he has been into very much of the controversy, in the mid of the controversy, and amidst all of these controversies, here is the question. is judiciary, specifically the office of Chief Justice of India, is it going to undermine the powers of the parliament? So the fact here is, if I am inside my boundaries, to be very honest, here comes the answer. If I'm following the protocols, if I'm following the ethical discharge, the code of conduct of my duties, apart from that, I'm having my boundaries clear and set, then whether I am the Chief Justice of India, whether I am the whole of the Supreme Court, the High Courts, the subordinate courts, whether I am the legislative wing, whether I am the executive wing, or any machinery of the government, any machinery of the democracy, doesn't matter. If I am inside my boundaries, if I'm not going ahead with the overreach, if I'm following the provisions that are given to me, the protocols that are given to me, if I'm simply abiding the law of the land, abiding the law of the constitution, and working for the sake of the establishment of the welfare state. Yes, sometimes it happens that I have to take a decision that that might be not, very famous, or that might be not, making many people happy. But yes, ultimately, if that decision, if the judgment, if that action has been taken in the name of the constitution, properly following the provisions of the constitution, not violating any of its part, then it doesn't matter even if the judgment isn't liked by the majority of the people. But the only condition is that judgment should be always, the action or the order should be always following the provisions and the protocols of the constitution. In case it is, then it doesn't matter. In case it doesn't, then whatsoever the public demand is, whatsoever the people's speculations are, even if the people are happy with that judgment, but in case it is violating the protocols, it is violating the constitution, it is violating the law of the land, it doesn't matter, right? So here, what are the features? Okay, here what are the things? That is the constitutional protocols about the judicial action. Okay, how judiciary is taken into the transparency as well as the answerability. So when we talk about the constitutional definition, so judicial accountability in the context of the Indian Constitution refers to the mechanism and principles that ensures that the judiciary, which is an essential branch of government, remains transparent, impartial, and accountable to the people and the law. It is vital for maintaining the rule of law, upholding the fundamental rights, and preventing any abuse of power within the judicial systems, for which the Constitution has given multiple protocols even. Like, for example, if you have a look at this, Article 124, that talks about the appointment of the judges, and apart from that, it talks about the removal as well. Appointment and removal of judges. How the judges are appointed. So there are 3 cases, in fact 4 cases, right, when we have to discuss about the judiciary's power in contrast with the power of the parliament. So here we have got 4 cases to be discussed. At any cost we need to, right? The first judge's case. The first judge's case. Or even before that, okay, before the judge's case, we just discuss about the appointment of judges. Appointment of judges in Supreme Court. As well as High Court, it is common as well. So how the judges they are appointed? So the judges, as of now, right, they are appointed by the President. They are appointed by President of India on the recommendation of a collegium consisting of Chief Justice of India and 4 senior most judges of the Supreme Court, right? This is how presently, as of now, with regard to the present protocols, provisions of the Constitution, judges are being appointed. Okay. Now, the cases. The first judge's case. It happened in the year 1982. In this, Supreme Court was asked that whether the advice rendered by CJI to the President is binding on President. So for which Supreme Court gave a judgment, no. The advice given by CJI when it comes to the appointment of judges to the Supreme Court is not binding on the President, right? Then comes the second judge's case, okay? Just if we switch the year, the second judge's case in the year 1993, okay? Second judge's case, 1993. The same question was once again in front of the judiciary, that is the appointment or is the advice rendered by Chief Justice of India to the President is binding or not. So Supreme Court reversed the previous judgment and said, yes, it is binding, okay, but not the CJI's advice alone. It should be CJI plus two senior most judges. Two senior most judges of Supreme Court. Then 1998, switching the year once again, it is now 1998. The third judge's case. Okay, this time it is what? The third judge's case. Okay. Once again, Supreme Court overruled the previous judgment, but this time didn't change the judgment, just upgraded it. What the Supreme Court stated? CJI's advice plus not two, four senior most judges. So hence, as of now, presently, the judges, they are appointed by the Chief Justice, by the President of India on the advice of the President, on the advice of the Chief Justice of India. Okay, so judges, they're appointed by whom? By the President on the advice of Chief Justice of India plus four senior most judges of the Supreme Court, right? This thing was challenged. Okay, the challenge came in the year 2014 when Parliament of India passed the 99th Constitutional Amendment Act 2014 that created National Judicial Appointment Commission, NJAC. It was a commission which was having the Chief Justice of India, the Prime Minister of India, okay. Then this was also having the Law Minister. This NJAC was also having the Opposition Minister, leader of opposition basically, okay, and some eminent jurist and eminent personality. For which judiciary stated this 99th Constitutional Amendment Act and the establishment of Article 124 capital A that talks about NJAC is absolutely unconstitutional, as it is undermining the independence of Supreme Court. Okay, Supreme Court in India, according to the theory of checks and balance and according to the Indian scheme of federation, is an independent integrated organization. It has nothing to deal with the executive and legislative wing. Hence, as a result, Supreme Court declared what? Article 124 capital A and the 99th Constitutional Amendment Act as absolutely unconstitutional, that is null and void. And hence, it was now the question that whether the Supreme Court is entitled to do this, such type of an act. Yes, Supreme Court can do this when it comes to the protection of the principles of the Constitution. And specifically, Supreme Court becomes more aggressive when it comes to the doctrine of basic structure. In case there is any statute or an enactment that has been passed by any state legislature or the parliament, and it is troubling somewhere the basic structure doctrine, the principles or the parts of the doctrine, the basic structure, then Supreme Court at that time becomes more aggressive. And now this time the case of CJI Chandrachud, the former CJI Chandrachud, it is now into the more of the limelights, as he has been given almost the clean sheet that no, he wasn't involved in any sort of corruption, any improper conduct, or any sort of abuse of office. And the next particular case comes into the picture when Mr. Prime Minister, he visited former CJI's home basically, for the sake of a puja. This was very much, something which divided the people's opinion. Some of them, they were of the opinion that what's wrong in that, and on the opposite side, there were people who were considering this act as a particular act which is opposing the principles of democracy. So basically speaking here, these are the matters of debate. It will be a very long debate for us to have it. And in fact, it will be not even right for us to have such type of a debate. Okay. So specifically speaking here, just in a very general way, there is no undermining of the power, neither by the judiciary side towards the parliament, neither by the parliament side towards the judiciary. Just the only condition that we need to keep in the mind, that if you are following the provisions of the constitution, abiding the law of the land and to the people's liberty as well, and going ahead with all of the ethical discharge of the functions, it doesn't matter whatever you do, you can do. But the only condition is, do not violate your boundaries, do not violate the law. Simple as that. Then we have got, for the further accountability, Article 217. This article deals with the appointment and removal of the judges of the high courts. In a similar way, Article 124 performs for the Supreme Court. So the appointment procedure and the removal procedure of the judges of the high courts under Article 217, as well as the appointment and removal of the judges of the Supreme Court under Article 124 is absolutely same. No difference. Okay. Third judges case 1998, we are still following it. Okay, for the appointment of the judges of the Supreme Court as well as High Court, that is, they are also appointed by the President of India only on the advice of a collegium headed by Chief Justice of India plus 4 senior most judges. On the contrary, they are removed on the very same procedure, that is, a resolution has to be passed inside the Parliament. Okay, with the special majority, obviously. In that meantime, there should be an investigating agency as well, which shall investigate the charges that are framed over a judge. Okay, and in case the investigating agency, the investigating committee finds the charges correct, then it will be, correct for the Parliament to proceed with the removal resolution, and then only it will be sent to the President of India, and when she signs, then only the judge will be said to be removed. And this is applicable to both, that is a Supreme Court judge as well as a High Court judge. Okay guys, so answer to the question, is CJI undermining or like dominating the power of Parliament? Absolutely not. Yes, there are instances which we need to consider, which we need to address, but yes, at present, nothing like that. Okay guys, so this is me, Praveen Mishra, signing off for the day. Thank you so much for watching. We shall be having the Hindu class in a very short span of time. So stay tuned guys, and please do not forget to subscribe to our StudyIQ IAS English channel. Okay, made with just one single purpose, to serve you. Okay, to let your dreams convert into the reality. Right, everyone? And apart from that, if you wish to connect with me, so we have got 2 platforms to connect further. It is Instagram. So my ID is Praveen Mishra _2107, and Telegram as well. Here you can connect with my channel, study_with_Praveen. Okay, guys. So thank you so much for watching. See you soon in the very next session. Bye bye. Take care. Study well. Jai Hind.